everyone. She'e Ethelbrand Shin Chef Bean Patwitney Nishlan Nakai Bashish Chin Sitner Jenny Dashache Adonakai Dashanella. Great to be with you again. She'e Deneba Washington Bit Agatit Aitso. I'm the nation's 13th Attorney General, and it's beautiful day. And I love snow, so Window Rock's getting a lot of snow. But I hope everyone is staying warm and is being safe on the roads. Make sure to take precautions, bring extra water, blankets, and all that jazz. Make sure your vehicle's gassed up before you start your trip. Make sure folks know that you're on the road. But please stay warm and safe, everyone. But we're happy to be here with you today for today's Lunch and Learn. We have Michelle Begay Nakai joining us from our Human Services and Government Unit. Michelle's going to be presenting on 638 contracts. Michelle does an incredible job of shepherding programs through that process, making sure that contracts are what they should be, and also plays a role in some of the litigation that we have relating to our 638 contracts. So with no further ado, I'm going to hand things over to Michelle. Thank you so much for joining us today, Michelle.
Thank you, Attorney General. Good afternoon. My name is Michelle Begay Nakai. I am a principal attorney at the Navajo Nation Department of Justice, and I have been working here for over 13 years. And as Attorney General mentioned, one of the things that I work on here is assisting the Navajo Nation's programs with Indian self-determination contracts. Yat Sheikh Michelle Begay Nakai and Shia Twitchin in the Shlon, Yay Denet Hachin Ibashin, Tohan Ada Shachedo, Kentlachini Ada Chanella. And as I noted, I've been working here at the Department of Justice for over 13 years now. And one of the things that I work on is the self-determination contracts that the Navajo Nation has with the federal government. And so this is what my presentation is on this afternoon. Okay. So the Indian self-determination contracts are under public law, also known as Public Law 93-638. This was a federal law that was passed in 1975 and has been amended several times in the past, and most recently was in 2020 by the Progress Act. So this is an important statute because it covers how an Indian tribe can contract with the federal government to provide certain services. It was previously codified under U.S. statutes at 25 U.S.C. 450, but it was renumbered in 2016 just because the way the statutes were numbered, it got a little bit too complicated because it had like 450D-1. So it was renumbered to provide some clarity to the different sections. There are also some federal regulations that were passed along with this, and they are as 25 CFR Part 900. So what is Public Law 93-638? So this is the federal law that allows Indian tribes to contract with the federal government to provide certain programs, functions, services, or activities. And that's an acronym that's usually used, PFSA, which is anything that the federal government used to provide for the benefit of Indians. So when you enter into a contract, the Indian tribes receive that funding directly that was appropriated by the federal government to provide those certain PFSAs. An important thing to note is when a tribe wants to enter into a 638 contract, the PFSA that they want to contract cannot be inherently federal. So that's something that only the federal government can do, sort of like passing federal law or doing anything that only the federal government can do itself. So the policy behind this law that Congress recognized within the statute is that they wanted to pass this law to give Indian tribes more control over federally funded programs that provide services and different activities to their people, while still maintaining the federal government's responsibility and relationship with tribes. As you know, you may know, the United States federal government and Indian tribes have a different relationship than the states do with tribes. So part of this is that the federal government still has responsibility to Indian tribes to ensure certain things are done. And this Self-Determination Act is a transition from federal to tribal control in the planning, conduct, and administration of the PFSAs that benefit Indian tribes. So what are some of the PFSAs that can be contracted? Programs that were operated by the federal government for the benefit of Indians. So some of these may be education, like the federal run schools. They used to have different types of boarding schools that the federal government actually ran. Those can be contracted, but there's also a separate process for those schools as well. Law enforcement services, so police services, detention services, different things that can go under law enforcement services. There's also agricultural assistance and also social services. There are different types of things under natural resources that are provided for Indian tribes. And then also, importantly, hospitals and health facilities, like health services that the federal government provides. So something important to note, that when contracting, there's a lot of, deference or decisions that the tribes have to make. The tribes do not have to contract to take on PFSAs. This law was just created by the federal government to give that option to Indian tribes to say, if you want to take over these, you can, but they don't have to. They can just leave it as it is, with the federal government providing all the services that I mentioned before. If that happens, then that's called direct service, because the tribes aren't doing anything and they're just receiving the services directly from the federal government. Further, as part of this, tribes can contract as little or as much of PFSAs as they want. They can take a little portion. They only want to do like the police services, but they don't want to take care of detention facilities. That's fine. Or they take over the Navajo Nation has the census office keeping track of tribal membership and how people are enrolled. They can also do that. Or they can take it all on. Another thing that we can do is the tribes themselves, the government itself does not have to take on the contracts to provide the PFSAs. The tribal government can also authorize what's known as tribal organizations to contract with the federal government to provide services. These can be tribal corporations or other entities that are authorized, mostly made up of tribal members or created under tribal law to contract with the federal government under 638 contracting. As for the Navajo Nation itself, we do have a mix of all of these. There are some instances where the Navajo Nation people still receive direct services. Most of these, a good example of this is probably the Indian Health Service. We still have Indian Health Service hospitals like Gallup Indian Medical Center, Crown Point, and Chinle. Those are direct services where the federal government is still providing medical and health services to Navajo people and other Indians who are located within Navajo Nation. The Navajo Nation government itself has contracted a lot of PFSAs from the BIA and from IHS. So those are contracts that the government itself has. And then the Navajo Nation government has also authorized some tribal organizations to contract or compact with the federal government on behalf to provide services on behalf of to Navajo members or Indian members. So what is a tribal organization? This is defined under the Self-Determination Act. As you see, at 25 USC 5304 1. So there are three types of bodies that can be a tribal organization. One is the recognized governing body of any Indian tribe. For the Navajo Nation, the recognized governing body is the Navajo Nation Council. Two, it can be any legally established organization of Indians, which is controlled, sanctioned, or chartered by the governing body. And three, a legally established organization of Indians democratically elected by adult members of the community to be served. So for number two, that could be most likely a corporation. As I mentioned earlier, some of the federally operated schools have been taken over by local school boards, which if you know of local school boards here on the Navajo Nation, those school boards are elected under Navajo Nation law. So that would be under three. And then number two would be any corporation that has been established to provide services. One of these would be a local hospital governing board, like, for example, there's the Tuba City Regional Healthcare, and I think Winslow also has a board. So all those three types fit under the definition of tribal organizations that can contract under this law. And this next slide just describes that as well. The tribal organizations can be corporations that are incorporated under Navajo law and state law. The Navajo Nation currently has 20 contracts, 2638 contracts with the Bureau of Indian Affairs. And these are under several different divisions under the executive branch. As I noted, we do have several with the, the Division of Natural Resources. There are a couple under the Department of Genetic Education, such as higher education, which are scholarship funding, and Johnson O'Malley, the Division of Community Development, the Division of Human Resources, which is the tribal enrollment, which I mentioned earlier. And also we have 4 contracts that fall under the Division of Social Services. And all these these contracts provide for services that the federal government used to provide, but now the Navajo Nation provides those services. Excuse me. Under the Division of Public Safety, we do have 4 contracts, 2 for corrections, 1 adult and 1 juvenile. Excuse me. Sorry. And we also have a contract for tribal courts, which is actually a contract that is handled by the judicial branch of the Navajo Nation. As noted, all the other ones that I mentioned fall under the executive branch. On this other side, with the Indian Health Services, the Navajo Nation does have 3 contracts with IHS. One is for health management services, which are several different services, and this is mostly done under the Navajo Department of Health. And we also have one for emergency medical service, which is under the Navajo Department of Public Safety, and then one other for that is administrated by the Navajo Treatment Center for Children and their Families under the Division of Social Services. And as I noted earlier, the Navajo Nation does authorize other tribal organizations to contract with the federal government. For IHS, the Navajo Nation has authorized Fort Defiance Indian Hospital and Sage Memorial Hospital to contract, as well as some other corporations to compact. And compacting is a little bit different, but for this presentation, these are regards to contracts under Title I of the Indian Self-Determination Act. So the act provides that when an Indian tribe wants to enter into a contract, they provide a request to the secretary of whichever department it is. For anything that falls under the BIA, it would be the Department of Interior, and then for IHS, it would be the Department of Health and Human Services. So when there's a request from the tribe, which done by tribal resolution, that the tribe wants to enter into a contract, then the secretary has to work with them to develop and enter such a contract. And the contract would not only provide for the direct services like the health services that a clinic or whoever that would provide, it also includes the administrative functions of the two different departments to support delivery of those services. As mentioned earlier, there was a more recent update to the Indian Self-Determination Act in 2020, and I think this was for the government to make sure that when these contracts are going through, there has to be good faith requirement, and that good faith requirement was added into the law back in 2020. And it just notes that the secretary has to at all times negotiate in good faith to maximize implementation of the policy. As noted earlier, the policy is for the federal government to provide for Indian tribes to have more say regarding these services that are provided to their people. And then that the secretary also has to maximize the policy of tribal self-determination. In addition to that good faith requirement, a rule of construction, which is usually used in federal Indian law, was also included and added to the act to state that the provisions of the contracting and funding agreements shall be liberally construed for the benefit of the Indian tribe. So if there's a disagreement between the tribe and the federal government or federal agency regarding what a contract or funding agreement says, it's supposed to be construed in favor of the tribe. So the procedure for new contracting, it's kind of a 3-step process. There's a proposal that's developed by the tribe and then submitted to the agency. And then that comes up with a final contract document. And then once that's agreed upon, there's an award of funding that goes back to the tribe. Under the law, federal law and regulations, when an Indian tribe wants to enter into a new 638 contract, the tribe can request technical assistance from the federal agency in order to develop a new contract proposal. This all goes back to the policy of the federal government wanting the Indian tribe to have more participation and more say-so over these activities that were previously provided by the federal government. Oh, this came out strange. I had a better graphic, but it looks a little bit weird on here. So there are different parties within the Navajo Nation government that are involved in the 638 contract. First, there would be a Navajo Nation program. They're the ones that go through with it. And then, for example, if it was a contract for police services or law enforcement, the program would be like the Navajo Police Department. They would be the primary program. They would be involved in it by writing out their scope of work, which just means the program services, the duties that they have in providing service to the people. And then next would be the Office of Management and Budget. Under Navajo Nation law, the Office of Management and Budget has a contracting officer and has certain authorities under Navajo law, and they are identified as a contracting officer who negotiates federal contracts on the benefiting the Navajo Nation on behalf of the Navajo Nation. And then, of course, there's the Navajo Nation Department of Justice where I work, and we provide legal advice to the programs, the government, the parties that are involved in this process. Next, the green slice would be the council, the Navajo Nation Council, who actually has authority to authorize the Navajo Nation entering into such a contract. And then the blue part is the signatory. For most of the contracts that we have, they are under the executive branch. So the president has signatory authority to sign off on those. But as I mentioned earlier, we do have a contract for tribal courts, and our tribal courts are under the judicial branch. So for that contract, Chief Justice has signatory authority for that particular contract. Okay, so what goes into a proposal? Under the law and the regulations, there's a whole list of things that need to be provided, and the one that I have on my slide is a very, very brief overview of what needs to be provided, but there's a lot more than that. But these are important ones. It has to say what tribes are going to be served under the contract. It has to include the tribal resolution that's authorizing the contract, the signature of the authorized tribal representatives. For most of our contracts, this is the president, but if it's for the tribal courts contract, then it would be the Chief Justice. And the important thing is the brief statement of the PFSA. These are the program, function, services, and activities. So this is what exactly are we contracting? We usually refer to this as the statement of work or scope of work, and that just describes what we're doing. So for tribal courts, it would be that we have the courts that are there to adjudicate Navajo law, or for social services to provide certain services to Navajo individuals related to whether or not they qualify for certain benefits, or for education, like for scholarship. They provide scholarship assistance to Navajo students who qualify for such assistance based on whatever's in place. There's also the amount of funds that is being requested. The Navajo Nation usually has a proposed budget for the upcoming year. This funding is done annually, so each year there is some type of proposal, but the overall initial contract proposal would include all of these things. The term, the proposed starting date and term of the contract, and then the date of submission. The date of submission when the tribe submits a proposal to the federal agency is also very important, because that is addressed in the Act and regulations. A 638 contract is considered to be an intergovernmental agreement under Navajo Nation law. So at Title II of the Navajo Nation Code, there's a definition for intergovernmental agreements. And it states that these are agreements between the Navajo Nation and another government that involve the sharing of governmental powers. And it specifically states that this includes Indian Self-Determination Act contracts. And because of that, under Title II, 164A, provides that intergovernmental agreements have to be reviewed and approved by resolution by appropriate standing committees and the Navajo Nation Council, except as otherwise provided. So in order for the Navajo Nation to enter into this type of contract, there does have to be legislation that's reviewed and approved by the standing committees and the Navajo committee. Okay. And I just have a statement there saying that this contract is between the Navajo Nation and the federal government to provide services that the federal government previously provided. So for Navajo Nation Authorization Authority, as noted before, the Navajo Nation Council is the Navajo Nation government's governing body. So under Title II, Section 701, it states that the Navajo Committee specifically has the authority to authorize, review, and accept any and all contracts with the United States under the Indian Self-Determination Education Assistance Act, upon the recommendation of the Standing Committee, which has oversight of the division, department, or program. So when we have to go through this process, the legislation does have to go through a programs oversight committee. So if it was the police department, their oversight is the Law and Order Committee. So that legislation would go to the Law and Order Committee first. And because it's involving funding coming to the nation, usually the Budget and Finance Committee also reviews these legislations. But the final authority to approve these contracts lies with the Navajo Committee. So here's the process for an initial contract or renewal. Under the Navajo Nation law, there is a process called administrative review, which is required. And that review requires review to be completed by the Office of Management and Budget, the Office of the Comptroller, and the Department of Justice for 2 NNC 164A. That's required for any intergovernmental agreements. Once that's completed, each office determines whether or not the document or the contract is sufficient, and then it moves on. If it's not sufficient, then the offices are supposed to provide written memo saying why it is not. Once that's done and everything's fine, then it goes to the legislative process. So that's when legislation is written up to say that they want to authorize the Navajo Nation entering into a contract. And that's when it has to go through the legislative process. The program would have to find a legislative sponsor who can request for legislation to be drafted. And once that's completed, it goes through the process of being assigned to appropriate committees. And then once that's done, it goes through each committee for action with the final approval by the Navajo Committee. When that's finally done and the legislation is completed to approve the contract, then the contract document proposal should be signed by the appropriate authority, the president or the chief justice, depending on which contract it is. And when that's finally done, it goes back to our Office of Management and Budget as the contracting officer for the Navajo Nation. They submit the entire packet to the appropriate federal agency, whether it's BIA or IHS. And once that's submitted, under federal law, the federal agency has 90 days to review, to approve, or decline. So going back to the federal law regulations, when the tribe submits a proposal, the agency has 90 days to review. These are 90 calendar days. So they have that timeline to review it and decide whether or not they want to approve or decline. If the federal agency feels like the 90 days is not sufficient for them to review, then they can request to the tribe to extend the review time. However, the review time can only be extended with written consent for the tribe. So if we submitted something to the BIA and they said they needed like 10 more days or 15 more days, they can ask the Navajo Nation, but they can't take that extra time until the Navajo Nation provides something back to them saying, okay, we agree, we will allow you to have some additional time. The reason why the date of submission is important because the regulations state that if a proposal that is received by the federal government is not declined within the 90 days, it's deemed approved. So if they miss their 90-day timeline, maybe 1 day or however days, then they don't have to provide anything back in writing to the nation. It's per the regulations, the proposal is approved. So when a contract or a proposal is approved, there's 3 different parts of the contract. One is the Model 108 contract. This is the main contract document that we have. And a lot of the provisions that are included are those that are included in the federal statute at 25 U.S.C. 5329. It states that this is a model contract, and all those provisions are actually included within the statute, and that's what we have to use as the main contract document. If an Indian tribe wants to enter into a 638 contract, it has to use those provisions. Those provisions cannot be negotiated or changed. The second thing is the authorizing resolution. This would be the Navajo Committee resolution that states it is authorizing the Navajo Nation government to enter into the contract with the federal government for whatever PFSAs that we are entering into. The third document that's attached is the annual funding agreement. This is another document, standard document that the Navajo Nation actually negotiated many years ago with the two separate agencies. There's one version for contracts with the Bureau of Indian Affairs, and there's one version for contracts with IHS. These documents were negotiated years ago, as the Navajo Nation has had 638 contracts for many, many years. And they have a lot of standard provisions that were agreed upon between the Navajo Nation and the federal government. This document includes provisions that state while the Navajo Nation is providing these services under the contract, they will comply with Navajo Nation laws and standards. And some of these include Navajo Nation preference, Navajo Nation employment policies, Navajo Nation laws, just the processes that the Navajo Nation goes through and that the government has in place. This can include like procurement policies, procurement laws. Some of the important contract provisions that are included in the 638 contract are the term. Most of these contracts are for 3 or more years. When a tribe initially enters into a 638 contract, I believe the preference from the federal government is that it be 3 years, so I guess they can see how the contract goes. Right now, the Navajo Nation itself, some of the 638 contracts, there are a couple that are 3 years terms, but most of them are for 5-year terms. And I believe a couple of the contracts that we have with the Indian Health Service are actually for 10 years. So the terms of the contracts can be different. And the terms that we have, they go by calendar year. So they start on January 1st of the year, and then however long the term is, it would end on the December 31st of the last year. The contract provision should also include standards that are to be used for administering the PFSAs. For example, we would say that the contract is going to be governed by Navajo Nation law, whatever policies we have in place, something that we're using to provide the programs, functions, services, and activities. They also should include a proposed funding amount because this funding is the funding under the contract is the funding that the federal government has already appropriated and would have used if the government itself was providing those services. The proposed funding amount is usually the same amount that was received the year before. This is a little bit difficult, and this is something that people always ask about, but because the federal government has a budgeting process that is kind of ahead, 2 years ahead, so the amount of funds that we receive in 2024 was already being determined or being talked about by the government back in 2022. So right now, I think the federal government is doing its budgets for 2026 right now. Another contract provision that's important that I noted that's usually included in the annual funding agreement is that the Navajo Nation can use its own policies regarding record keeping, personnel, and other things. There is a provision for monitoring. So the federal agency can come to the Navajo Nation and do a monitoring. Before, the Navajo Nation had agreed to annual monitoring. So each year, BIA or IHS could come out and see how the Navajo Nation is providing these services under the contracts. However, with the 2020 amendments to the Indian Self-Determination Act, it states that there only needs to be 2 monitoring reviews per contract unless the tribe agrees to more. So if it was a 10-year contract, the federal agency would only be allowed to do 2 monitoring reviews during that time, unless the nation said, okay, we agree to have more monitoring reviews. Another important provision is that any contract funds, 638 funds that are received under the contract are available until expended. Most of the times, the programs are should be able to expend the funding we receive because the funding is received annually. So we receive funding for a year, and they should be able to expend that fund in the year. But if we are not, and it goes into the next year, we are supposed to be able to continue to keep those funds. In other words, any funds that aren't spent within the year, they do not revert. They still continue to be available for the nation to use until it's expended. And the contract also provides notice of the designated representatives for the parties. As noted, the designated contracting officer for the Navajo Nation is over at the Office of Management and Budget. So we have identified him also as the Navajo Nation's designated representative as well. And then we also make a note of who from the federal agency is also their designated representative to talk about our contracts. So contract funding. Under 638 contract, we receive the amount of funds that the federal government would have used to operate the PFSA. So the amount of funding that we actually get under the contract is what the federal government has already appropriated. And that's usually the amount that Congress has set aside for that. So for police funding, we do receive some services. We got a certain amount of funding for our scholarship, a certain amount of funding for social services. And usually this isn't sufficient to meet the needs that we have, but that is the amount of funding that is under the contract. Some other things to consider funding under a 638 contract. There are some startup costs that can be received, but this is when you only have your initial contract. Those are one-time things, like if you need to set up certain things, you need to set up an office, you need to set up certain things. Those are one-time costs that can be provided. Another thing that we receive is contract support costs. There are direct and indirect. So each year, these are the costs that help to support providing these PFSAs to our people. So the reasonable cost to operate a program. There are also indirect contract support costs. So like for the programs that we provide for police services, for social services, there are other offices who assist them in doing the work that they do. Like for the Office of Controller, they help keep track of the funds and process payments for different things that the police may have to do or the social services may have to do. Although they're not directly providing those services to the people, the work that they do also supports what these programs are doing, and those are known as indirect contract support costs. And usually that's paid but through an indirect cost rate that the Navajo Nation negotiates with the federal government as well. The 2020 amendment that updated the Indian Self-Determination Act also added a section relating to reimbursement rate for indirect contract support costs. The amendment states that the reimbursement rate shall be considered reasonable and allowable if the rate is not less than 50% of the expenses incurred. So what if we go through this whole process, we submit our proposal and give it to the federal agency, and the federal agency looks it over and says, okay, we don't agree with what you're having here. We disagree with what you're providing. They can decline the proposal. But if they do so, then they have to provide a written notice and also provide technical assistance to the tribe to address whatever issues there are, and also provide the tribe with an opportunity to appeal. And if a federal agency does decline a proposal, they can't just decline it for any random reason. The law and the regulations do provide that there are only 5 reasons that the federal agency can decline. The PFSA if they say that whatever they're contracting for under the scope of work or whatever services that have been proposed by the tribe will not be satisfactory. So they have to say it's not going to be satisfactory and why they feel it's not. Or if they feel that there's inadequate protection of trust resources. So as I noted earlier, the Navajo Nation does have several natural resource contracts. One of those is like forestry, where they maintain the forests within the Navajo Nation. If the BAA felt like there wasn't enough protection of those types of resources, or like the water resources, we have a water resources contract, then they could possibly decline it, but it has to be specific to one of these 5 reasons. The proposed PFSA cannot be properly completed or maintained by the contract if the agency sees that there's something in there that they don't think is going to work or going to be addressed by the contract appropriately. They can also do that. This one is more common than number 4. The amount of proposed funds is more than the applicable funding level. So if the nation said that they wanted so much money for providing social services, the federal agency would say, well, this, we can't give you that whole amount. We can only give you this lower amount. That's usually the most common reason for declination. And 5 is that the PFSA includes activities that cannot be lawfully carried out by the contractor. This most likely would go to like something that I mentioned before, the federally inherent service or program. In contract renewals, once the term is expired, the tribes have to submit renewal proposals or the intent not to renew at least 90 days before the expiration of the contract. As noted, the Navajo Nation contracts are calendar year. So if we were doing it by that way, the goal of the Navajo Nation is to submit these renewals by October 1st of each year. Within the term of a contract, there is successor AFA. This is, as noted, these annual funding agreements are done every year. And these include the following attachments: scope of work, budget, any reporting that's required under the contract. There are certain reports that are required, like for the police, they have to file special incident reports, or for the tribal services, they have to make note of how many court reports they have. And these also have to be submitted 90 days before the expiration date. So we have the similar goal of October 1st each year. When we do an AFA, I noted that these documents were previously negotiated, so there's hardly any changes made to them every year. Because of that, they would be pretty much the same each year. So they should be approved by the federal agency with whatever funding is available. But if we decide to make any changes to our funding agreement and it's not the same as the previous year, then they can be subject to declination. The successor AFA, which is the one done within the term of a contract, it does go through an administrative review per 164, and then it's signed by the president or chief justice, and then it's sent to the federal agency. However, these ones do not require legislation because they're being done within the term of the contract. Budget consultations. So every year the federal agencies have to meet with tribes to develop their upcoming budgets. I briefly mentioned this earlier. These are done 2 years in advance. During these consultations, the agencies ask for the tribes to provide certain things to them related to the federally funded programs. This may include what are the tribe's budget priorities? Where does the tribe think they need to get more funding? What are some unfunded obligations that the tribe has done, but they're providing certain services that don't have enough funding? These are information that the nation provides to both agencies. Under 638 contract, we don't have to provide the services the same way the federal government did. We can make changes to them, and this would be called a redesign. This would be based on any needs that we see, the geographic, demographic, economic, cultural. We can include some things related to genetic culture to, if we feel like providing services that way would be better, we can make those changes, but they would still have to be evaluated by the secretary and can be subject to declination. But since the whole purpose of Indian self-determination is for tribes to take more control, and they do need to take that into account as well. So if a tribe is providing services under a contract and something happens, there's some type of violation of rights, or there's endangerment of health, safety, welfare of the people, or if there's just gross negligence or mismanagement of the funds, if any of these are found, the secretary or the federal government can rescind the agreement and resume control of the PFSA. So if they find that the nation isn't doing what it said it would, or there's something happening under the contract, they can be rescinded. However, they do have to provide written notice and provide for the tribe to resolve those issues. Another thing that could happen is the nation could say, well, we don't want to do these things anymore. We'll just give it back to you, BIA or IHS, and let you continue to provide the services again. In that case, that would be called a retrocession. And they just want the federal government to take those services back. So that would require writing back to the federal government and then an indication of when they want the federal government to resume the services, which can be 1 year after the date of request, the expiration of the contract, or another date. Okay, that's all I have for now in my presentation.
Thanks so much, Michelle. That was really, really great. I saw that there were some comments, so we'll go ahead and highlight some of those. Lots of great jobs. So kudos, Michelle. And let's see. Okay, some commentary about subcommittees involved. Okay. Yeah, not very much here. There's a comment that about federal contracts. And the nation adding policies that are not in the contract. I think this is mostly relating to medical, like the IHS 638 compacts. There's a person saying that they needed dental service. And the aging department said that they had to participate at a senior citizen center before they could be assisted.
I'm not sure about that. I don't think the nation has any dental services within our PFSAs, but I know that some of the hospital boards have contracted most of the other things. Like I think probably Tuba City does have that.
Mm-hmm.
I'm not sure what they mean by the aging department say they have to participate.
Yeah, that's unusual. I've not heard of that before. I wonder who. Usually the dental care services would be directly at the 638 facility, right?
Yes.
Care facility. So there shouldn't really be any interaction with the aging department.
Yes.
So I guess for that listener, LJ Nelson, maybe work directly with the healthcare provider, and they should be able to assist you. Although I will say, I know I tried to get my son in for a dental appointment at Fort Defiance, and the waiting time was like 3 or 4 months. And so I don't know how well the service delivery is on the dental side. And so,
I think it may be one of those that are underfunded, like all the other programs. So maybe they don't have sufficient staff as well.
Mm-hmm. And then we have someone else saying that they have a question, but they didn't post their question. And that's pretty much it. It's a lot of information. And then we have a question: why does the nation take so long to draw down federal funds that programs receive? I don't know if you want to take a go at that question.
In regard to 38 funds, I don't think we can draw down anything until everything's completed. Luckily, this year we were able to submit most of our proposals early before the October 1st deadline that I was talking about earlier. So the nation did receive awards before the end of December. I'm not sure which exactly they're saying is taking so long to go down. A lot of it depends on the programs itself and how quickly they put their documents together and everything goes through the appropriate processes.
Mm-hmm.
Is there an echo?
I don't hear an echo.
Okay, I kind of
I
do.
wonder if this also has to do with, the first in, first out issue. And, some of the funds, I guess administratively, there's been a challenge in spending the older dollars before the new dollars. And so that's something that Michelle has worked on very hard in the last year. And I think we've made some progress, but it's still a work in progress.
Yes.
Yeah. And then let's see, let me look at the additional comments. I don't really, there's a comment with a bunch of acronyms. I'm not sure what the question is exactly. Okay. Well, that's pretty much what we have for today. But thanks so much, Michelle. And it's a very complex process, and a very complex in terms of how the nation is proceeding. Michelle mentioned the many contracts that we have under 638. And it's, there are some things that, like, our police department wants to be able to do that require amendment to the contract. So as the programs are spending the dollars, they have to stay true to what's within their contract. And in order to expand services or change service delivery, then that has to go into the new contract, or there has to be a modification of the contract. So it's a complex process. And as Michelle mentioned, these are 3-year contracts typically. So it's difficult to make sudden changes, essentially.
Yeah, most of them are 5-year contracts. There are a couple that are 3 years.
5-year, okay.
So
that makes it even more difficult, because then you may not be able to even change it within one administration.
And because the contract with everything, including the proposed scope of work, is authorized by the council, if there was like major changes made to how they want to do them, it likely would have to go back through legislation again.
Mm-hmm. Wow. Okay. Well, I think that wraps things up for today. And thank you so much, Michelle, for all the time you put into this, and the clear presentation that you provided. And thank you to all of our listeners. We'll see you next week. And just a little sneak peek of what lies ahead for next week: we're going to have Paul Struan on, the Assistant Attorney General for our litigation unit. He'll be giving you a year in review of what has been happening in federal Indian law litigation. So tune in for a summary of those developments. And thank you again for listening. Yeah.